Pretrial detention persists as a chronic human rights issue in Europe. 1 in every 4 prisoners in Europe are retained or remanded. In other words, before final conviction. The figures vary significantly between the countries, from 11% in the Czech Republic to 42% in Italy. These people have not been tried at all, or they are awaiting for the review of an early sentence. As their guilt is not established, they should be regarded in principle as innocent. There is an obvious human rights dilemma here. Pretrial detention decreases or reverses the detainee's presumption of innocence, aggravating his position with an unjustifiable presumption of guilt in the eyes of the public and those of the judges. Pretrial detention must be seen as a measure of exceptional nature. There should be a presumption for release pending trial. Detention must be applied only when all other measures are judged to be insufficient, according to the proportionality principle. The reasoning behind a pretrial detention decision should be made clear. The most important is establishing why the alternatives to pretrial detention are not sufficient. Such alternatives can be bailing or being forbidden to travel and to meet certain persons, or the obligation to appear before the authorities at a certain time of the year. Many times the justification for the abuse of custodial detention is repeatedly and typically given as arising out of the danger of new felonies being perpetrated in the future. That means that if the defendant is released, he or she is bound to commit additional crimes. But the presumption of innocence permits the defendant to be considered innocent even for the case he is tried. In no case should felonies of which he is not accused and might never occur into consideration. This would be equivalent to detention without trial. Additionally, the alleged risk of obstructing investigation does not constitute a sufficient reason to impose pretrial detention. It is not easily acceptable that the functioning of the judicial mechanism relies on one person. In any cases, there are more lenient and effective measures in order to secure the smooth operation of the investigation. Similarly, the alleged risk of flight does not constitute a sufficient reason either, because it punishes the defendant for a crime that has not been perpetrated and he has not committed. The prevention of the offence of flight belongs to the police and not ours. Another concern is the duration of the pretrial detentions. Some states have already established a legal maximum length, while others allow pretrial detention period for excessive period of time, such as up to 4 years. The ultimate goal should be the harmonization of the legislations of member states with common framework of rules. All actions should be done in full compliance with the right to freedom and the presumption of innocence.